All right, good morning. Thank you for having me. My name is Courtney McCarthy. I think Kate and I are going to introduce ourselves and then we'll kind of start going through the slide of our presentation. As Tia had mentioned, I'm an attorney. My office is in Arlington, Virginia, and I work primarily in Northern Virginia. I am the founder and principal of McCarthy Law PLLC, which is located in Arlington, Virginia. And I do family law, divorce, custody, support issues. I also do estate planning, estate administration, and some other law guardianships. And so those two areas of law overlap, which is one of the reasons why Tia reached out to both Kate and I. We both have somewhat similar practices and understand the overlapping of this. I've been a guardian ad litem since I've been practicing since about 1995, and shortly after I started practicing, I became a guardian ad litem, which is an attorney who's appointed to represent the best interests of an individual who's before the court that has some alleged disability. And I've been doing that for children since about 1996, and started with adults about 3 years later, so about in 1999. Kate, you want to introduce yourself?
Yeah, sure. Thank you. Hi, I'm Kate Mcqueen. I'm an attorney, principal attorney with Alfred Kerman. My office is in Bethesda, but we have offices going from Charlotte, North Carolina, all the way up to New York. I am licensed in DC, Virginia, and Maryland, and I've been in practice about 20 years. Like Courtney, my practice focuses on family law, just typical family law, divorce, not that anything in family law is typical, but divorce, custody, child support, those issues. And then about the other half of my practice is guardianship work, fiduciary work, and that involves helping families with adults and children who have special needs and trying to figure out the unique issues that can arise in those families. And it is a lot of times those two practice areas do intersect, and that's where I really find that is the piece of my work that I enjoy the most. So I want to thank ARC Northern Virginia and Tia for having me today. Thank you all for attending this on Zoom. I know we're probably all a little Zoom fatigued, but hopefully we can give you some information that'll be helpful. And I'm thankful to have met Courtney through this because it's not typical for attorneys to have this kind of unique blend of practices. And, you know, our names are similar, our practices are similar. In fact, we look a little similar. So,
I was thinking the same thing.
Yeah, I'm thankful to have met Courtney. And I hope that we can, you know, we've worked together to put together a presentation for you all that I hope you'll find helpful.
Okay. So I'm going to move my pictures to the side so I can see the slides. Okay, so if you can start, thank you. So we're going to start going through the slides, but you know, one of the things that I think Kate and I hope that you take away from this presentation today is the importance of working with an attorney early on in the process if you're going to be going through a divorce, in order to get an understanding of what your options are, what likely outcomes might happen, what the law is, and maybe even within your local jurisdiction, what the nuances might be. Because even though there is a set of laws that are set up for the state of Virginia or the state of Maryland or DC, sometimes the way that those laws are implemented, or you know, the ways that the judges will see certain fact patterns may differ from jurisdiction to jurisdiction, or even the procedures that the attorney has to follow through. And so it is very important to consult with an attorney who practices in the area, geographical area where you're, I would say is very important too, in the geographical area where you will be going through the divorce, to kind of help guide you through some of those nuances. When you're talking about a divorce, you're talking about three main areas that a court is looking at in making decisions. Talk about support, both alimony and child support. Alimony is support that is paid from one spouse to the other. And child support is support that's paid from one spouse to the other for the specifically earmarked for the benefit of the child or children of the parties. And then you're also looking at issues of equitable distribution. And that means, how do we divide up the property of the family? And then the third is when you've got children and children with special needs, we're looking at issues of custody. And we're going to talk a little bit later about also how that segues into when you've got a child with special needs and they become an adult, and what the courts will do regarding the issues of continuation of child support. So the way we've set up these slides is we kind of started with Virginia first, and then added some of the differences in Maryland. So Kate and I are going to kind of go back and forth on this. So the first slide we're talking about is talking about alimony. And so in Virginia, we have what are called spousal support guidelines, and what guidelines are, and we have spousal support guidelines, and we also have child support guidelines. And what guidelines are is it is a way that the legislature set up how to calculate an amount that the courts can look at when they're determining how much money are they going to order one spouse to pay the other. In Virginia, the spousal support guidelines are only presumptively correct in temporary spousal support matters when the total monthly income between the parties is below $10,000. So what does that mean? So temporary spousal support is just when a court is putting in an order that is saying this is a temporary order until we can have a more complete hearing on the matter, where the judge can actually hear a lot of the details about the circumstances of the marriage and the factors that the court will listen to and consider when actually arriving at a final amount of support. As I said, in Virginia, we have some guidelines, which is a calculation the court will do, but it's only presumed to be correct when the total monthly income between the two parties is $10,000, and it's a temporary support order. You'll also hear the word pendente lite. It's a Latin term that is what is referred to as a temporary order. It's just for the pendency until a complete hearing can be held. And in Virginia, the support guidelines for spousal support that they use is if the parties have a child in common, then the calculation of how they come up with a temporary support amount is the difference between 26% of the payer spouse's gross monthly income and 58% of the payee's gross monthly income. So the person who is paying, the court calculates, okay, what's 26% of their gross monthly income? And then the person who is to receive the support, what is 58% of theirs? And then it's the difference between that the court will award in a temporary support. If there are no minor children, then the calculation is different, and it's changed to 27% of the payer spouse gross monthly income and 50% of the payee spouse. And this is a new change in the Virginia legislature. They had a slightly different percentage, but as of last July, they changed the calculations, and that was based on previously when spousal support was paid, the spouse that was paying that support was allowed to deduct that amount that they were paying from their taxable income when they did their income taxes at the end of the year. And the spouse that was receiving it had to count it as income on their tax returns. A few years ago, that rule was changed. The IRS changed that. And so for any support that is done after, and hopefully Kate can remember the date, I think it was 2 years ago, anything that was done before is under the old rules. It still is something that is taxable to the receiving spouse and deductible to the paying spouse. But I think it's the last 2 years, it's now changed so that if any new order from that point forward, it is no longer deductible to from the payers and taxable to the payee. We have the next slide. As I said, that there are the spousal support guidelines are presumed to be correct in temporary support orders. In all other actions, and when the court's making a final determination, they do not consider the guidelines. From a practical standpoint, there are many judges that I've seen that want to know what the guidelines say. But instead, what the court's going to do is it's within the court's discretion as to how much they will award. And so in Virginia, there's a list of factors that the court needs to take into consideration when deciding how much are they going to award in spousal support. And this slide is showing some of those: the obligations, needs, and financial resources of the parties, the standard of living established during the marriage, the duration of the marriage, the age, physical, and mental condition of the parties, and then any special circumstances of the family, the extent to which the age, physical, or mental conditions or special circumstances of any child of the party would make it appropriate for a party not to seek employment outside of the home, the contributions, monetary, non-monetary, of each party to the well-being of the family. We have the next slide. Next slide. The property interests of the party, and I'm probably not going to go through all this. So, but what the court in the divorce has decided about the equitable distribution, earning capacity of the parties, opportunities for a party to obtain skills to enhance their earning, decisions being made by the parties regarding employment during the marriage and how that's affected both parties and their ability to earn and their future earning potential, the extent to which the parties have contributed to education or training for the other party, and other factors such as tax consequences. So when we're talking about families who have children with special needs, remember that this is spousal support. This is support to the other parent to help them because of looking at these factors, and the court's going to take into consideration some of the factors in here that's most important that the court looks at are things such as the earning capacity. You have one spouse who maybe is taking the primary responsibility of caring for the child with special needs. And so they forwent a career while the other parent was able to work and improve their future earning potential. Those are some of the things that the court will take into consideration when determining, are we going to award alimony? And if so, how much are we going to award to the other spouse? Because they have essentially put their career and their earning potential on hold in exchange for having to provide care for a child with special needs, or even if not providing the daily, during the day care, maybe there are other things they need to do by coordinating with caregivers or schools or programs. Next slide, please.
Okay, so Maryland has no guidelines for alimony at any stage in the process. And when you're thinking about, divorce and a family where you have a child with special needs, and the process, and really any divorce process, the benefit that guidelines give you are certainty, whereas the drawback they give you is that sometimes the result of the guidelines may not fit your family. But certainty is a benefit in that I have to tell clients in my Maryland cases that you really don't know what the court will do for alimony. It depends very much on the court, the judge, the day, maybe what the judge had for lunch, maybe, whether it's a full moon, you just don't know what's going to impact the court's decision on alimony. Like Virginia, Maryland has statutory factors to consider for alimony. And on this slide and the next slide, I set forth those statutory factors. Maryland does not have one specifically tailored to are there needs of a child for which a party may have, taken a step back from the workforce in order to focus on the child's needs. But that is something the court is going to take into consideration. The court has to consider these factors, but it can consider any factor that's necessary to make a fair and equitable award. And as all the attendants for this presentation probably know, a child with special needs requires most likely one parent or both to take significant steps that take away time, attention, and energy from a career. And so the court is going to consider that. The question is just how much consideration is that going to get? And in turn, what difference is it going to make for alimony? Because the question is always how much and for how long. So if we can go to the next slide, we'll see the rest of the statutory factors for alimony. So you see here that it talks about the physical and mental condition of each party. It doesn't necessarily address the physical or other conditions of a child that might have special needs. And then if we go to the next slide. So talking about alimony and how much and for how long, there's there's really three types of alimony in Maryland. One is pendente lite, which is what Courtney was talking about. In Virginia, they have the guidelines for, and that's what support is going to be paid to a spouse while the case is pending. The other two types of alimony are for once the case is either settled or determined by a trial. And so that's either rehabilitative or indefinite. And rehabilitative means it's for a certain period of time. And during that period of time, the spouse who's receiving the alimony is expected to pursue training or get experience to allow that spouse to increase their earning ability so that they can become self-supporting. And so if you're, the period of time, if you're settling, could be 3 years, 5 years, 10 years, whatever it might be. If you're going through a trial, it's going to be a shorter period of time. Indefinite alimony means that the alimony is paid until there's a terminating event or a court order or agreement modifying the alimony. And so indefinite alimony has, as years have passed and genders have become, both have become more equal in the workforce, the courts have veered from indefinite alimony towards favoring rehabilitative alimony. So in order to get indefinite alimony, you have to show that either these two factors shown on the screen here, due to age, illness, infirmity, or disability, the party seeking the alimony can't reasonably be expected to become self-supporting. Or even if they are able to become, even if they've made as much progress as they can make, the respective standards of living between the parties will be unconscionably disparate. And that's a fairly high standard, but that's meant to address, if you have one spouse who's earning millions and the other spouse who is, working at IHOP or something, making minimum wage, that would be unconscionably disparate. And so the courts, would probably issue an indefinite alimony award there. And the things that courts are looking at is the length of the marriage, age of the parties, other factors that would make the court more likely to order indefinite alimony rather than rehabilitative alimony. And so kind of thinking about that framework, we want to go to the next slide, please.
Just a quick, excuse me, Kate, would everybody please remember to put your questions in the Q&A and not the chat so that we can answer them better that way. Thank you.
When we're thinking about alimony, particularly for a family where there's a child with special needs, you want to think about what you can do to make sure that you're protecting the family and the child for the special needs that are going to continue. And there are terminating factors, like I said, for alimony. One is remarriage of the spouse who's earning the alimony. The other is if either the recipient or the payor dies. And so when you're thinking about either settling, entering into a separation agreement, or going to trial, you want to think about life insurance for the payor of the alimony, so that if that person does pass away, the alimony payments don't end and the recipient spouse is left, unable to support him or herself and the child with the special needs. In addition, you could think about life insurance for the parent who is the caregiver for the child. If there's if a spouse is working outside the home and the other spouse is primarily the caregiver for the child for special needs, if something were to happen to the caregiver parent, the parent who's working outside the home would have to pay for a caregiver. And so you want to think about perhaps life insurance might be a way to protect against that risk as well. If you want to go to the next slide. If you're just beginning the divorce process, it's important to know that you've got to figure out alimony now. You can't wait and deal with it later. You could ask the court to reserve that in the judgment of divorce. In Maryland, that's very limited circumstances, but you can do that. I'll let Courtney, when I'm finished talk about whether that's more likely to be had in Virginia. But it's, really you've got to deal with it now. And you've got to think about, okay, here's what I need now. What am I going to need maybe in 10 years, 20 years? What is life going to look like? Another thing to think about is the alimony going to be non-modifiable or modifiable? And what that means is that if you have a judgment from a court, at least in Maryland, the alimony is going to be modifiable. Either party can go back to court if you can show a material change in circumstances and ask the court to change the amount or the duration of the alimony. Part of a separation agreement, you can agree that the alimony is going to be non-modifiable, meaning that no matter what happens, nobody can go back to court and ask the court to change either the amount or the duration. So if one party loses their job, if one party becomes ill or gets hit by a bus, you can't go back to court. You can, as part of a separation agreement, try to hit a middle ground there where, let's say, it's going to be non-modifiable unless I can show that I have a severe disability and I'm unable to work for a year or more. That's an example. Or, they're called disaster clauses. So, if the unforeseen disaster happens, that's no fault of the spouse who's supposed to be paying alimony. You try to give that spouse some sort of way out of a non-modifiable alimony payment that could really put them in trouble if, something awful befalls them. Then another thing to think about is that alimony, while it's no longer taxable to the spouse who receives it or deductible to the spouse who pays it. And Tia, you were right. I think it's December 31st, 2018 is when that tax change happened. It is still considered income to the recipient for child support purposes. And we're going to get into child support in just a minute, but for which there are guidelines and for which you consider both. There are guidelines for most circumstances, but you consider each party's gross income. And the party who is receiving the alimony, their income includes the alimony payment for child support purposes. So that's just something to think about as well.
So to follow up what Kate was saying, in Virginia, we also have rehabilitative support. Virginia has a few other options that apparently Maryland doesn't have. So Virginia does have the rehabilitative. They do have indefinite, but the court can also award spousal support for a defined period of time or a lump sum. And so the Virginia courts have a little bit more flexibility in how long the duration that they can award spousal support. Like Maryland, there are circumstances where it terminates automatically if either party dies or if the party receiving it remarries, or in Virginia, the spouse who is paying support can also ask the court to stop the spousal support if the spouse that's receiving it is living with it for more than 12 months, is living in a relationship with another person, which is considered analogous to marriage. So most of the time, parties don't necessarily agree that they've been living in that relationship for more than 12 months because they don't want the spousal support to stop. So often that is an issue that has to be litigated to the court, and the judge needs to make that determination whether or not that judge believes, based on the facts and circumstances provided to them in the hearing, that the spouse receiving support is in such a relationship. The reservation of spousal support in Virginia is something that the courts do. The maximum amount of time that they will allow for the reservation period is 1/2 of the amount of the length of the marriage. So what that means is, if, let's say, you, from the date of marriage to the date of separation is 20 years. If the court does, in the divorce, award a reservation of spousal support to one of the parties, they can allow them 10 years from the date of divorce to come back to ask for spousal support. And during that 10 years, if that spouse comes back, ex-spouse at that point comes back to ask for spousal support, they would have to go through, and the court would make a determination based on the factors that we talked about prior. And as Kate was saying, spousal support, as I said, Virginia, they do have the guidelines, and it's presumed to be correct only in the temporary support, spousal support orders. But spousal support tends to be one of the most litigated issues in divorces, because there is so much discretion with the judge as far as them making a determination of whether they're going to award it, and if so, how much and for how long. Can we have the next slide, please? Okay, so we just finished talking about spousal support, and now we're going to talk about child support. So as the name implies, child support is support for the child. The purpose for this support is for the basic food, to provide assistance to the parent that the child is living primarily with, for basic food, sheltering, and clothing. The child support also encompasses issues of medical coverage. The child support order will establish which parent is going to be providing the insurance, medical insurance. It also establishes a percentage of responsibility between the parents for any uninsured, unreimbursed medical expenses. In Virginia, the default on how the court decides how much or how they're going to split the percentage up is based on the parties' respective incomes. We certainly see a lot in situations where parties negotiate settlement agreements where they will change the percentage, and they will become creative with what their monthly child support is going to cover, and then putting in other provisions as to extra things like activities or school fees or camps, things like that. Child supports also establishes in Virginia, they can also include, and again, I'm going to get to a second about guidelines, but when they're determining how much the guidelines are, they can also include if there are routine medical expenses that are happening on a monthly basis, that can be included in the monthly child support that's awarded. And then it also encompasses work-related child care for the child, and how the percentage of that gets divided up. Can we have the next slide, please? So in Virginia, when is a child eligible for child support? So under the typical circumstance, a child of the parties is eligible for child support until the age of 18, unless they are still in full-time school. Then it's 19, or when they graduate, whichever occurs first. And this is as long as the child is not self-supporting and is living in the home of the person seeking child support. So if you have parties that are separating and a child is living with another relative, then the parent who's seeking support isn't eligible to get support from the other parent. So what happens if you have a child with a disability? In Virginia, there is also the ability for child support to continue after the age of 18 or 19 if the child's still in school, as long as the child meets the criteria for regular child support, meaning not self-supporting and living in the home of the person seeking support. But you also have to establish that that child is severely or permanently mentally or physically disabled, that this disability existed prior to reaching 18 or 19. So what that means is that this child had this disability when they were eligible before for child support, and that you have to establish, the court has to establish that the child is unable to live independently and is residing in the home of the parent seeking or receiving child support. Next slide, please. So when do you file? Okay. So typically what I recommend to parents is if your child is approaching the age of 18, then you ought to consider starting the process of filing to have that support to be extended. You can wait, and in fact, you can do it later. You can do it, you can have a situation where a parent's paying support, the child with the disability turns 18 or 19, is in school at 19, and that parent then stops paying support. And then a couple years later, the parent who the child is living with files for support and asks for child support to resume because the child has a disability. Practical tip, I wouldn't wait that long, because the longer you wait, the more difficult it might be able to establish to the court that the child was actually disabled prior to reaching 18 or 19 years. If the court does determine that the child meets all the criteria for extending the support or continuing the support or starting the support back up if it had stopped, then that support will continue for as long as the child is alive, unless it's brought back to court and the court determines that there is a reason that the child no longer is eligible. Next slide.
Okay, so Maryland law on child support is the same in terms of children who are under the age of 18, meaning that it's payable until the child reaches 18 or graduates from high school, whichever is later, but not later than the age of 19, unless the child is what Maryland defines as a destitute adult child. And the interesting thing about Maryland is the statute is found as part of really criminal penalties for a parent who does not support a destitute adult child. And it used to be support of destitute parents as well. It was part of a whole statutory scheme about supporting destitute family members. And so the Maryland statute, as it presently is, provides for this to be enforced by the state's attorneys, but it is also used as a mechanism to seek support for an adult child with a disability. And so the term destitute adult child, though, does not mean that the child has to be living on the street. It means that the child has expenses that cannot be met by what the child can earn. So the child could still, have a job, but not be able to pay his or her expenses with that employment income. And so a child could receive even SSI benefits and still be entitled to support under this statute. The court cannot consider trust funds to which a child may be entitled under the statute. What the court does is basically look at the expenses of the child, the income of the child, and if there's a deficit there, the court can order one parent to pay support. And it's typically, the support's typically calculated using the same child support guidelines that are used for children under the age of 18. Thankfully, Maryland does have guidelines for child support, which, like I said earlier, is just you input each party's gross incomes, what each party pays for the child for health insurance, work-related child care, and if there's any medical expenses, ongoing medical expenses that either party pays, that's put into the guidelines, and the formula then gives you a number for what that child theoretically needs to support him or herself each month. And Maryland, the guidelines are presumptively correct where the parent's income, combined gross monthly income, is $15,000 or less. That's going to change as of October 1st of 2021 with a great big leap to $30,000 or less. So essentially doubling the amount of income to which the guidelines are presumptively correct. And what that means is you have to show the court that the guidelines are unjust under the circumstances. If the gross monthly income is above $15,000 now or $30,000 as of October 2021, what happens is then you have to get into a broader analysis of the child's expenses and each party's ability to pay those expenses. And then the court may enter a different support amount. But like I said earlier, the benefit of guidelines is they do provide some certainty, and the benefit of certainty in a divorce case or any kind of negotiation between the parties is that it gives each party less wiggle room to fight, and that means less attorney's fees, which is good for everybody. If we can have the next slide, please. Maryland statute is, sorry, can we go on to the next one? Thank you. The Maryland statute is interesting in that it orders a parent to pay support either to the adult child, or to the public, to the agency that has responsibility for the child. So if they're in a group home or something like that, and the group home is representative payee, you would pay that group home. It does not allow expressly for payment to a parent or a special needs trust. And that can cause some problems because the receipt of child support by a child over the age of 18 can impact that child's eligibility for means tested benefits. And so you want to really be careful about doing this for an adult child. And it's, if the child has a special needs trust, what I've done in the past is had the parties agree that the support's going to be irrevocably assigned to a special needs trust. And that is consistent with what the Social Security Administration requires so that the child can remain eligible for SSI benefits. If we could have the next slide, please. So this statute that provides for support for a destitute adult child, there is presently a bill in the Maryland legislature to repeal it. And I'm not sure why. I tried to find information on why this was introduced, and I couldn't find anything. I didn't try to call the delegate's office, but I would be concerned if this were repealed, because I do think that this statute, while it's fairly rare in the grand scheme of family law cases, it is really helpful to particular families. And so I would be really concerned if this were repealed. So I think the next slide goes back to Courtney.
Similar to Maryland, Virginia has child support guidelines that are presumed to be correct. And similar to Maryland, it takes into a lot of the same factors in order calculating it, including the average gross monthly income of both parents. And when we talk about income, it's all income, not just taxable. It's taxable and non-taxable, but in Virginia, they specifically do not include if a parent receives benefits from public assistance or social services program or federal SSI, or if they're receiving child support for another child. That is not part of the parents that are involved with this particular child support calculation. The guidelines also put into how many children are being covered by the child support. what the cost of the monthly health insurance premiums for the children are. And when we say for the children, a parent may have a family plan that, let's say it's $500 a month that they're paying for the premium for that. And that it's covering the parent and 3 kids. If that's all that's being covered on that, the question is how much more is the parent paying per month for the insurance policy to have the children on it? So in that circumstance, let's say they had a policy that had an individual policy was $300 a month. The difference between that, the $200 is what would be used in the support guidelines. They also take into what are the costs of the work-related childcare costs, what's the average. And so, for example, sometimes during the summer, there are more camps or other childcare needs because schools are not in place, or maybe there's not a program that the child can go to through the schools. And so they average those costs over the year into a monthly amount. It's important to understand that when they are plugging in these numbers into the guidelines, that is not that the Virginia support guidelines do not contemplate putting respite care, the cost of respite care, into these guidelines, unless it can be shown that this is related to work-related costs. Next slide, please. Also in the guidelines, they take into consideration the number of days that the child is with each parent. In Virginia, the definition of a day is a 24-hour period. If the child is with a parent, let's say custodial parent and non-custodial parent is a term that is used. Custodial parent often refers to the parent that the child resides with the most, and non-custodial, although we're going away from those terms nowadays, but non-custodial is the parent that the child is with less time. And so the definition of a day is if the child is with the non-custodial parent from a 24-hour period, that's considered 1 day. If the child is with the non-custodial parent for less than a 24-hour period, but it's overnight, then that's considered a half a day. And those number of days throughout the year are calculated. And then we have 2 different types of guidelines. There's the sole guidelines and there's the shared guidelines. And in Virginia, we also have a third, which is a split sole guide. And there's different definitions of how many days will change whether you're using a sole guideline or a shared guideline. We can have the next slide, please. Okay, so in Virginia, sole guidelines. These are used if the one parent, and when I was referring before, I said non-custodial parent. This would be what you would consider the non-custodial parent. One parent has the child under 90 days a year, and there is a set of guidelines that is used for that. If both parents have the child for over 90 days a year, then they use the shared guidelines, and the difference in the calculations has to do with adding in to the calculations the amount of time that the child is with both parents. Under the sole guidelines, they would be with one parent a lot more. And as they start spending more time with the other parent, the idea is what I was terming custodial parent has less expenses because the non-custodial parent is picking up some more of the expenses for the child when they're having the child with them more. As I said, there's also split guidelines. That starts to get a lot more complicated, and that will factor in if there's more than one child and the children have different schedules with the different parents, that can affect the guidelines. Kate, you want to talk about Maryland?
Yeah, I'm just going to pop in and talk about Maryland. So in Maryland, it's determined by who is, can we go back 2 slides? Yep, perfect, thank you. In Maryland, it's determined whether it's shared or sole custody is determined by the number of overnights. And until October 1st of 2020, it was either sole or shared, and the difference was pretty stark. It was 128 overnights was the dividing line, and the difference in terms of monetary amount for child support for someone who the other parent had sole custody versus having shared could be pretty stark, meaning $1,000, sometimes more than that difference. And it often led to people really counting the number of overnights on the calendar and getting into big fights about it. And so the legislature, as of October 1st of 2020, instituted a more tiered system, which is more complicated, but it is more reflective of the difference that child support is meant to incorporate, meaning that child support is meant to be a payment of the expenses for a child when the child's not with you. One thing to kind of think about, though, is that if you're at the start of your negotiation or trying to think about divorce and what it's going to mean for you in child support, the court is much more limited in terms of what it can order for child support than you are if you're negotiating an agreement. And that's the benefit of the agreement, is you can be more creative. Like Courtney mentioned, in Virginia, the child support doesn't cover respite care. That's true of Maryland as well. You could take that into account if you were going to negotiate something. You could take into account, payments for camps that are not child care camps, payment for bar mitzvahs, bat mitzvahs, payments for tutoring. These are things that the court is not going to be able to order, but an agreement could. And if there's specific expenses that are, applicable to a family with a child with special needs, you would want to really consider what you might be able to do as part of an agreement that the court is not going to be able to do. And another thing to kind of think about is that child support is also always modifiable if you can show a material change in circumstance. Maryland also has the split custody if you have more than one kid on different schedules, but it is complicated, so I don't really think it's worth the time to get into that here. And then we get into DC on the next slide. DC still has the pretty bright line test of 128 overnights is the dividing line for sole versus shared.
We have the next slide.
And Courtney, you want to talk about this one?
Yeah. So, as we said, the guidelines are not flexible enough for families with children with special needs. The guidelines are presumed to be, the child support guidelines are presumed to be correct. However, in Virginia, the judge can deviate from the amount of the guidelines. They have to first establish what the guideline amount would be, and then they'll go through a list of factors, and I'll get to that in a minute, as to whether or not they're going to deviate and why. Really, as I said, these guidelines are not flexible enough, especially it's much more expensive to raise a child with special needs than a child who does not have special needs. As many of you know, there's the costs of healthcare needs, prescriptions, the supplements, the diets, the therapies, all of that. While the guidelines will split it into a percentage of uninsured, unreimbursed medical expenses and which parent would be responsible for which. Sometimes we see parents disagreeing about whether or not it is a reasonable or necessary medical expense, as to whether or not they agree that they should be splitting it or not. Also doesn't take into consideration sick days, which is absolutely a big impact on parents who are the one that is primarily caring for the child with special needs, and impacts their ability to increase their earning capacity. We have the next slide. So as I said, they're presumed to be correct, and in Virginia, the judge can deviate from them, but they have to put in writing what the presumptive amount would have been and what they are ordering as a deviation and why. And here's a list of factors that the court looks at in determining if they're going to deviate from the guidelines. And I'm not going to read all of these. I will say that number 8 For sure, any special needs of the child resulting from any physical, emotional, or medical conditions is one of the main factors that we see when we have a deviation of support argument. The number 3 we see somewhat frequently when we have parents who are divorcing, and typically the parent who is the higher earner doesn't believe or agree that the other parent needs to be providing as much care for the child with special needs. And so they are trying to establish to the court that they believe that that parent should actually be able to make or have a higher earning potential. Next slide, please. Independent financial resources of the child or children is one that we see an argument that is raised typically by the parent who is going to have to pay support. The argument being that the financial resources, if the child is receiving some other financial resources, we sometimes see parents saying that that's something that the court should take into consideration. And I'll get to that a little more down the road. And then 15, such other factors as are necessary to consider the equities of the parents and children. We can have the next slide. As I said, independent financial resources of the child. For example, and the child support guidelines, I'm not sure if I'd said this before, in Virginia, they apply to children under the age of 18, as well as children with disabilities when the payment of child support is extending past their age of majority. And so the independent financial resources of a child can be taken into consideration by the judge when determining whether they're going to award what the support guidelines say or some deviation from that. In Virginia, there is a specific part of the statute of the code that sets forth a mechanism in which the court is to incorporate a child's SSDI payments into the guideline calculations, meaning payments that the child is receiving as a derivative from one of the parents. There is a specific way that is incorporated. But regarding all other financial resources of the child, it's completely within the discretion of the judge as to whether or not they're going to take that into consideration in deviating from the guideline amounts. In my experience, most of the times the judges typically do not consider including the child's income unless it is a very large amount of income, or the judge considers it's going to be very inequitable for the parent who has to pay support to be able to pay that. Because typically, in most circumstances, children with special needs don't have a lot of independent financial resources, if any. But also, I think the judges do recognize that it is a lot more expensive to provide for a child with special needs. And so, as I said, typically they're looking at it from the perspective, if they feel like it's not a hardship for the parent that is going to be paying to pay the amount, then they typically don't.
Courtney, this is Tia. I want to jump in real fast. That's your experience in Northern Virginia, correct? Because I think that the attorneys in Northern Virginia have done a very good job educating judges on people with special needs and the financial burdens on the family. I don't know what it's like, and I'm sure Kate will get to it in Maryland and DC, but also in other parts of Virginia, because like I said, there seems to be a lot more effort in keeping the judges up to date on reality.
And I think that's a very valid point, and I'm glad you actually said that. You know, my experience again is in Northern Virginia, and that's what I've seen. But I think you're right. I think that the court's exposure to special needs, families with special needs in general, is a lot more. There's a lot more exposure in Northern Virginia than there are maybe in some of the more rural areas of the state. And so it's not only education by the bar or advocacy groups, but also how often do these issues come up before the judge, for them to, you know, each time you're in court, a judge is supposed to be judging only on what's before them. However, we as attorneys know that they may, you know, it's at least in Northern Virginia, they may have had this type of issue come up many times before, and even with experts in there, and somewhere in the back of their mind, they glean some important information from that previous that they may even subconsciously consider when making a determination in your case. Because, you know, judges are human, just like all of us. And, you know, we all base our opinions not only on what's in front of us, but what we believe is common sense, and whether that common sense is, you know, where that's coming from, if it's influenced by something in the past that we've heard or said.
Right, and you're right.
Which is
the
another reason.
population, so we're so densely populated here in this area too. That's right as well. What you said, that they hear it and see it much more frequently, whether it's in their courts or in the news. It's very present very often, where in other areas it may not be as prevalent.
Which
Courtney.
is also another plug, I guess, for saying, you know, if you can work things out, you're going to be much better off if you can work at an agreement that's going to be customized to your family situation. Because again, well, one, what we're just talking about, you know, the judges are human too, and they're getting this information, just a snippet of your family in a short period of time to make a decision. And they can have a lot of discretion in some of these issues that are before them, and maybe they have their own biases. But two, they're also limited in what they can do based on what authority they have under the laws. And so families are typically in a much better position to craft an agreement that is going to be unique to their circumstances and work to their benefit. You know, I typically say to my clients, you know, really having to rely on the judge is the last thing we really want to be in a position to have to do. And we really need to try and exhaust every other reasonable option before that, because most of the time no one wins, and you end up spending a lot of attorney's fees. And especially in families with special needs, the resources are scarce enough as it is, that it really needs to be preserved as much as possible. Next slide.
Okay, so I'm going to talk about Maryland a little bit, and just following up on what Courtney and Tia were saying. I do think that it has been my experience in Maryland, and I do practice mainly in Montgomery County, but I sometimes in Howard County, and for guardianship work really across the state. I mean, I do find that different courts' approach to special needs or disability issues differs, but it's also judge by judge. And as Courtney was saying, I think every judge approaches a case, you know, they're human. They approach the situation with their own lens that's colored by their years of practice, what they did before they took the bench, what they've seen when they've been on the bench. And it's our job, if we have to go to trial, to educate the judge on the certain circumstances of a family, particularly if there are special needs, and what that may include for expenses or custody issues or guardianship issues, whatever it may be. But you never know what the court is going to do. And you never know what particular lens the judge is going to see your case through, unless, I mean, sometimes if you practice in a place enough, you kind of know what that particular judge's circumstances are. But in Montgomery County, every judge is on a rotation, and family law, I think, is 2 years. I could be wrong, but then you may be assigned to a judge, and that judge is double booked, and so then your case gets sent to a judge who, hates family law, or is just trying to fit you in between 2 other cases. So it's really to your benefit to try to work things out to achieve what you can for your family. And going back to the child support piece, the court is more limited in what it can do. And I've seen this with families where, you may have a child, adult child or minor child, who has a condition that you believe is really helped by holistic treatment, or you believe is really helped by horseback riding or some sort of other therapeutic intervention that would not be included in the definition under Maryland law of what a medical expense is that the court's going to order the parties to share the cost of. But you believe it's very helpful to your child. And oftentimes when a family is going through a divorce, I've seen parents kind of take opposite. You become more polarized in decisions about your child sometimes. And, one parent may take an opposite position on something like holistic treatment, where because they're just taking a contrarian position. But if there's a way to work it out so that you can make sure your child gets that, if you have to give up something else that you don't love giving up, but you're willing to accept it, that, I almost always tell my clients to do that, because you don't know what's going to happen in court. And, you have a judge who may earn less than what the parties earn, and may look at horseback riding, for just as a hypothetical example, as an extravagance rather than a necessity. So anyway, going back to the black and white of Maryland law on child support, this slide talks about what I had already talked about, the guidelines being presumed correct and the changes to the income levels to which the guidelines are presumptively correct. Maryland law is a little bit different about when the court can deviate from the child support guidelines, and frankly not as detailed as Virginia law seems to be, but this slide sets out what the court has to consider when determining whether it should deviate from the guidelines. And then if we can go to the next slide, if the court does deviate from the guidelines, then the court has to examine financial circumstances and the rest of the issues that are detailed on this slide. And then if we can go to the next slide. One other thing that I don't think I touched on is just that child support in DC, just to be aware, goes until 21. So the age is a little different in DC. So if we look into how to pay child support, like I had talked about previously a little bit under Maryland law, but this is true of really law in any state, because a lot of the benefits for an adult child with special needs are federal and means tested. So you need to make sure that you do what you need to do to preserve those benefits. And often it's an irrevocable assignment to a special needs trust. And Courtney can talk about Virginia law, because it looks like Virginia law that addresses this better than Maryland law does. Maryland law does not expressly provide that, at least under the adult destitute child statute, that it would be specially assigned. So I'm going to hand this over to Courtney.
Okay. Yeah, so a few years ago, we were running into problems of situations where we had a family and they had a child with special needs. And as Kate said, when you're going through a divorce, sometimes the parties become a lot more polarized. And we were running into some situations where you may have a parent who is going to be the one that's going to have to pay support. And this is for a child who's now an adult with special needs. And when everybody was in agreement, and typically we didn't have too many problems with judges signing off on orders that said that the support was irrevocably assigned to a first party special needs trust. And again, the purpose of that is if the child support, which is considered support of the child, is paid irrevocably into a first party special needs trust, then Social Security Administration does not count that as income against the child for purposes of them being eligible for SSI and other means tested benefits. but there was nothing in the law that specifically authorized the judges to do this. And so we were running into situations where maybe the parent who is paying didn't either was trying to use, wasn't consenting to the payment to go into a first party special needs trust, and would either just flat out refuse or would use that as some sort of negotiation tactic to try and get the amount that they would be paying to be less, because we were finding a situation where the parent that child was living with primarily would have to either, forego the child support or take much more reduced in order for the child to be eligible for the SSI. And if the child wasn't eligible for the SSI, not only was there a monetary amount that they would be losing out, but sometimes that was the segue into other benefits that the child could have. And so a couple of years ago, the Virginia legislature changed the law to specifically authorize in the statute that a judge can order the child support to be irrevocably assigned to a first party special needs trust or an able account if either party asks that to be done. Since that has changed, there's been some discussion among, and I do not do special needs planning. I have colleagues that do and are on Special Needs Alliance and everything. So I've learned through them that there's been concerns. It was not only the Special Needs Trust, but the legislature also says, or assigning it to able accounts. But recently there's been some discussion of concerns of having it irrevocably assigned to an able account may not actually preserve the SSI and means tested because of the child's access to the able account where they don't have any access to the first party special needs trust. So anytime I have a parent in here in my office and we're dealing with child support for an adult child with a disability, I'm always recommending that we put it into the first party special needs trust so that we don't even have to run into the possibility that putting it in an able account will cause a problem.
Okay,
one caveat though. Go ahead.
Before your caveat, so there was recently a presentation on the ABLE regulations that have now been finalized, and they did not at all speak about so I've never heard of it ever being irrevocably assigned to an ABLE account, and it was not in the presentation. And to my understanding, the only time the child support does not count as unearned income toward the adult child is when it is irrevocably assigned to the first party trust. And it is looked like it is considered unearned income in the eyes of Social Security wherever else it goes.
Yeah.
So that was very
so the reason
twisted, but go ahead.
Yeah. So the reason I raised that is because the Virginia Code actually affirmatively says the judge can order it to the first party, irrevocably assigned to the first party special needs trust or an able account. And when these legislatures are debating these laws and enacting them into to become laws, it's a very condensed time frame that they, and not all of the laws, but some of them, it's a very condensed time frame that they're having discussions and they're learning about this, and then they're having different people weigh in on it. But sometimes they don't have a very long study period for determining this. And so I think that the issue of the ABLE account was something at the time, maybe we didn't flesh it out enough for the legislature. I'd only raised that because it is in the code, and I have heard concerns that don't rely on that because that might not work for federal benefits.
Right, exactly.
So, okay. And so, but the caveat with this in Virginia is that there is a department called the Division of Child Support Enforcement, and they are tasked, and in their, that entity exists in the other states in the United States. And their purpose, as it says, is to enforce child support. And many people who are paying child support will pay it through the Department of Child Support Enforcement. So the payor pays it to the Department of Child Support Enforcement, and then the Department of Child Enforcement, DCSE, will then pass it through to the parent of the child. And then that's an independent agency that keeps track of, yes, the payer has paid it, and if they're not paying it and they're getting behind and getting in arrears, then they can instigate actions in court to get the payer to catch up. However, the Division of Child Support Enforcement will not be involved in child support cases where it's irrevocably assigned to special needs trust. And it's not in Virginia code, it's in their policy. And I didn't get a clear answer on this other than the extent of, because their policies require there to be an actual person that is supposed to be the recipient, not an entity. Next slide. So child support is always modifiable by the court. And parents can't contract away the modifiability of it because, and what does that mean? So spousal support, parents can decide, you know, parent A is going to pay parent B X amount of money per month for 5 years, and then it's done, no modification whatsoever. The court will enforce that. But when it comes to child support, the court says parents can't contract away the child's right to the support. And so the child support can be modifiable at some point down the road. But what has to happen is the person who's asking the court to modify it has to show that there's been a material change in circumstances that has happened since the last court order of child support, which justifies a change in the support. And if there's a hearing on that and the judge is, okay, yes, I believe there has been a material change, then the next part of that hearing is, okay, and so now what is it going to be changed? So for example, a party may lose a job, become ill, the child's needs may increase. I mean, these are just some of the common examples, but there's many other reasons why it could be considered modifiable. Next slide. So other items to negotiate for a child with special needs. So we've touched on a lot of this sprinkled in, as Kate said before, life insurance. That is something that you should be looking into and thinking about when you're trying to negotiate some sort of settlement with your spouse. Virginia does have a code section that can order a parent to maintain life insurance that they already have as part of the child support. But it has to be something they already have. And it also would say, you know, for as long as it's reasonably available to that. If it's, let's say it's through an employer sponsored insurance policy, typically you would see the court saying they have to maintain it and it has to be maintained for as long as they have a duty to provide support, and it has to be as long as it's reasonably available to them at a reasonable cost through the employer. Again, special needs trusts. So there's first party special needs trusts and third party special needs trusts. First party special needs trusts, some of you may already know this, but first party special needs trusts are trusts which are funded by the disabled individual's assets or income. For a proper first party special needs trust to work, one of the main components of it that differs from a third party is that there is a pay pack provision in it. And what that means is the trust says, let's say the trust is for John Doe. It's John Doe's money going into the trust. It's for the benefit of John Doe. It's in a properly prepared and funded special needs trust, so it's not being considered a resource for purposes of his eligibility. But when John Doe dies, there is a provision on that trust that says, okay, whatever money's left in the special needs trust has to be paid back to Medicaid or other means tested benefits that they've received before any other distributions can be made to any other beneficiaries of that trust. Third-party special needs trust is payment from third parties. So, for example, parents' estates planning. I have seen situations where instead of child support, parents saying, well, we're not going to pay child support, but we'll both agree that we're going to be putting money into this third-party special needs trust for the benefit of the child. So the benefit of that is there is no payback provision, but you have to be very careful when you're using that, if you're using it in lieu of child support, because we always worry that an eligibility worker might look into, you know, a divorce decree or settlement agreement a little more carefully and question whether or not there's something funny going on. Also, pooled trusts, again, Northern Virginia has them, and they can be quite effective for in your negotiations with each spouse in order to, especially as part of your estate planning, to ensure that there is money that is going to be set aside in these trusts for the benefit of the children. And sometimes we have situations where the parents that are separating, they are rightfully concerned about their finances and are they going to be able to, you know, support the child while they're alive and support themselves. And, you know, the expenses are now more because there's two households, but the income hasn't changed, or maybe even it's less. So sometimes that's a negotiation portion of this is, okay, in your estate plan, we're going to make sure that there's a trust established for Johnny, that one or both of the parents is going to make sure that they're funding money into it either during their lifetimes or as part of their estate plan. Respite care, I've seen situations where parents negotiate in their agreement as to the parent that has the child the majority of the time needs respite care, and is the other parent going to actually be the one providing that respite care, or are they going to agree to payment for the respite care or some division between the parties of how that respite care is paid for? Because remember, that's not respite care unless it can be termed in some way that it's also related to work. It's not something that normally goes into the calculations of the child support guidelines. Also, maintaining the marital home. I've seen this issue come up quite a few times in families that are divorcing with children with special needs, that one parent wants to maintain the marital home because it's important as far as the child with special needs and having that continuity. And so I've had parents who have offset that with some other division of some asset. I've also had parents, usually the ones that are a lot more cooperative with one another, willing to agree to, because they believe and trust the other parent that it really is for the benefit of the child, willing to forego something else that they may have been able to be entitled to in order to ensure that they're maintaining the marital home for the child. And then also periodic review of finances, always important. If you can get both parties to agree to do that. Kate, you want to say anything about any of these?
I would just say that as far as the marital home in Maryland, at least, divorcing spouses, one party, if a party has custody of a child, they can ask the court to award use and possession of the marital home up to 3 years. And that can include an order for the spouse who's use and possession means that that spouse can live in the house, the other spouse can't come in, even though it's jointly owned. And that order can include a requirement by the spouse who's no longer living in the home to contribute to the expenses of the home. And the theory behind that is, in any divorce, you know, parents often feel like it's going to be a disruption to the children, and to the goal of the use and possession is to maintain the stability for at least a certain period of time for the children, if it's possible. But it can also be used in a case with children with special needs. The thing that people also need to think about, though, is that any property transfers that happen pursuant to a divorce order or agreement are not subject to taxes for the transfer from one spouse to the other if they happen within a certain period of time. And so once you get beyond that period of time, there are concerns about whether, for instance, if one spouse is going to maintain joint ownership of a home, but then agrees like in 10 years to transfer it, that might be subject to tax penalties because it's outside the period of time allowed for those transfers under tax law. So it's getting into the weeds a little bit, but it's just something to kind of think about. You want to try to negotiate, if you're trying to negotiate maintaining the marital home, it's certainly something you can do, but you just want to make sure that you don't create any unintended consequences.
Our next slide. Did you want to do this one, Kate?
Sure, yeah, okay. So another thing that often becomes an issue for parents who are divorcing with children with special needs is decision-making. It can happen with custody issues when the child is under the age of 18. It can also happen when the child reaches the age of 18 and over. In DC, Maryland, and Virginia, once a child reaches the 18, that child is captain of their own ship, for better or worse. In most circumstances, I have a 16-year-old, so the older he gets, the scarier it seems to me that he's going to soon be making decisions for himself. But if your child has special needs and is not able to make those decisions for himself or herself, then you need to think about guardianship. And it can become more complicated when the parents are divorced rather than remaining married, because then it can become, an extension of the divorce dispute. Something to be aware of is just depending on the jurisdiction, there are different terms that are used, even though the meaning is pretty much the same. In DC and Virginia, they use terms guardian and conservator. And the guardian makes the personal decisions for the person under guardianship, meaning healthcare, where they're going to live, sometimes education. And the conservator makes the financial decisions. In Maryland, they use different terms. They use guardian of the person, which is the same thing really as guardian in the other two jurisdictions, and guardian of the property, which is the same thing as a conservator in DC or Virginia. And so hopefully we've been talking about special needs trusts and other types of planning. Hopefully you can do some planning so that you don't need a guardian of property for an adult child with a disability. If you have a trust and all the property that the child has is in the trust, or the child might be entitled to is in the trust, and there's a trustee handling that, you don't need guardianship of the property or conservatorship because the trust handles that. The benefit of having a trust is it's often subject to less report. There usually are reporting requirements associated with the trust, but they're often less than those associated with guardianship or conservatorship. Whenever there's a guardianship, the court is always the ultimate supervisor of what's going on with that guardianship or conservatorship. You have to file periodic reports. It's always modifiable if somebody's doing something wrong. Oftentimes the conservator or guardian of property has to post bond, so there's a financial burden there as well. So if you can avoid guardianship of the property or conservatorship, it's better off if you do that. If the only income your child receives is Social Security, Social Security does not recognize guardianship anyway. They have a representative payee process that they handle that is, I'm not going to get into my beefs with Social Security, but as with any bureaucracy, it can be challenging to deal with them. But they do have their own process. And so if that's the only income that your child is receiving, you're not going to need guardianship of the property or conservatorship. Can we go to the next slide? Or maybe that's the last slide. The thing to think about for guardianship of your disabled child is, how is it going to work between you and your spouse if you're divorced and have problems reaching an agreement? Because if you're not able to reach agreement, the court's going to be really concerned about whether to appoint you both as co-guardians, and you should be concerned as well, because you do not want to continue the divorce dispute if you're at all able to avoid that. You know, you could put in, if you can reach an agreement, again, even a guardianship order can, if it's by consent, can allow you to be more creative than the straight up guardianship order that you're going to get from the court. So you might give one person authority over certain decisions and the other person authority over other decisions, or put in some sort of dispute mechanism, tiebreaker or something like that. But it's an issue that needs to be addressed. And sometimes it's just going to be one spouse is going to become guardian and the other spouse isn't. And that, if that's how it has to be, that's how it has to be. But it's just something to kind of think about. And the earlier you can address it and hopefully try to reach a resolution, the better. So I think that's it for us.
Excellent. Thank you guys. That was a lot of fantastic information. I hope everybody was able to follow along. At the beginning, in the chat, you were told that you'll be receiving everything via email. So everybody RSVP'd via email or via the website, then we have that information and can send this out to you later for reading. I'm going to jump to the questions. There are quite a few questions. There are actually 24 at this point. I'm going to start at the top, and maybe, I know I didn't ask this, and I know if I know who you are, I'll be able to say Virginia or Maryland in case there's a difference between the two. But the first question that came in, which is open to Kate and Courtney, is how does child support change when the child turns 18?
So
Maybe you guys want to do every other question? Yeah.
Well, I'm assuming you're talking about a child with special needs and wanting to continue to receive child support for a child with special needs. If you're talking about a child who doesn't have, isn't considered disabled, then child support will end when they turn 18 or 19 if they're still in high school, full-time school, 19 or when they graduate. But for a child with special needs who's considered to be disabled, meets the definition of disability, you need to file a petition with the court to have the court affirmatively extend the child support past the 18th birthday. In that order, the court is in fact making the determination that that child meets the additional criteria for disability and extending the support. The guidelines are the same, but at that time, it may be that if you're having a hearing as opposed to an agreement between the parties, it may be that the judge at that time is looking at, okay, what are the current incomes of the respective parents and the other information that's put into the guidelines.
Yeah, I agree. It would be the same in Maryland, and it would be the court, I think, would look at the current incomes of both parties.
Thank you. And I'm typing up answers and sending it out, and don't get tied up in my typographical errors. So this is Virginia. When a guardianship is put into effect, does the previous custody agreement become null and void? If so, how does one get the custody agreement reinstated? The ex believes that it's in effect with regards to custody hours, and so if it's legally no longer in effect, I would like to get that. And you guys can read along, by the way.
Oops, sorry. Custody orders are only for a child under the age of 18. Once they're no longer, once they turn 18, they're an adult and they're considered under the law to be able to make their own decisions. So any custody order that you had in place prior to a child turning 18 is no longer in effect for that child. I have seen circumstances where a parent or someone else gets guardianship of the child now that they're an adult, but they fit the criteria for having the court to order a guardian. I have seen orders in the guardianship cases where the parties, either on their own or through a judge, have put in some sort of custodial schedule. But typically, if I see that, it's mostly when they have been, when the parties have agreed to it. Some judges look at guardianships and say, this is not a continuation of your custody dispute. This is solely regarding which parent I'm gonna, is gonna be the one that makes decisions for the child now that they're an adult. And so I've seen some judges that say, I'm not gonna get into that at all. The issue of when the child's gonna be with one or with the other. I'm just solely gonna decide who gets to make that decision, and then that's it.
Maryland law specifically allows for the court to put in a visitation schedule, but I would agree with Courtney that in practice, it's viewed as something very different. The court's not going to get into, days and holiday schedules and all that kind of thing. The court's going to say, who's the decision maker here? And then if the other party specifically requests some sort of access, Maryland law allows that to be granted.
Well, and let me follow up on Virginia about the guardianship. Virginia law specifically says a guardian doesn't have a right to deny access between the ward and a person that they have an established relationship with, unless essentially what it says is the guardian needs to get the court to weigh in as to whether or not they can restrict their access to them. That's a little bit different than deciding over when the child's going to be with one person or the other. That restriction in Virginia is more related to their denying them access completely.
Okay, thank you. I think this is Virginia too. When a child turns 18 and who has been disabled since birth, when a child turns 18, does mom have to go through a child support case again with discovery to include these factor questions? Or does the court go with a past order and update child support accordingly? In other words, do we have to go through litigation for the obvious?
So you do have to file a new petition, and that always opens it up to subjecting the court to looking at whether or not the actual amount that's being paid will continue to be the same amount or not.
Sorry, I'm typing a question. So Evelyn, can you unmute Neetha? Neetha had the question above about the guardianship versus custody issue, and she wants to provide more information for further clarification. Evelyn, can you unmute Neetha, please, or did you? Yeah, go ahead, Neetha. Let me see. There you go, Neetha.
Yeah. So two things. This is Neetha. When I had the custody agreement written up, I had it written that the the child support would continue beyond his age, the age of 18, and that was done in, I didn't know all of this till now, but it was done in civil court, and so that has been held up. I didn't have to go back to court when he turned 18, although my ex did stop payment and I had to get another lawyer involved, but that's another story. But the court document said that the child support would continue beyond the age of 18. So I do get child support, and my son's 19 now. So I don't know if somehow went around it and didn't
So-
realize I was going around it. And then the guardianship, so that means like nothing in the custody agreement is no longer in effect, basically. If the guardian, can I have the guardianship kind of refer to the custody agreement and say that everything that's in there stays in effect or continues to stay in effect?
So let me make sure I understand correctly. You all had a settlement agreement that got incorporated into final order?
Right, correct.
Okay.
And it's
And
pages,
so in,
pages and pages and pages long. I mean, it was very painful. So
and
I
so for
don't
the
wanna go
support,
through that. Sorry.
that's all right. And for the support matter, did you specifically put it in there that the child is disabled, meets the criteria for extended child support, and therefore the support will continue past the 18th birthday?
Yeah, we did, but my ex
Okay.
tried to wiggle out of it and then came back and agreed and continued to pay for it. Yes.
Okay. So whenever you have an agreement and it's incorporated into a final order, that final order is deemed, unless the order says otherwise, it's deemed to have made those findings and that are in the agreement. And so what you essentially were able to do, but through the agreement, was everybody agreed that your child was disabled, met the criteria, and that it was going to continue past the 18th birthday. That still doesn't prevent the court from reviewing it in the future if someone asks for the court to do that about child
Sure.
support. But they have to allege that there's there's been a material change in circumstance.
Sure. Yeah. And I found this the weird way because I found out that the child support services can't enforce it because apparently it was decided in the civil court or the other court. I don't know what other court. Because when he stopped paying, I tried to get it back and they said that it wasn't done in their court. So I just wanted to throw it out there because I know you said that you had to go back to court at 18. So.
Well, that's unless so you all had an agreement. When people agree on things, most of the time, it makes it a lot easier and less time having to go back to court. If you hadn't had an agreement and you went to court on this, and let's say your child was 12, I don't see any judge being willing to enter an order at age 12, finding them to have this disability at 18, that they'll have this disability at 18 because it's too far off. And they would take the position that as you get closer to that age, we have to know whether or not, because the child's circumstances possibly could change and not meet the criteria. But since you already had that in your agreement and the court incorporated it, then you didn't have to go back at 18.
Thank you.
Thank you.
Everybody.
I
Next
will say,
question.
I think can we talk about, I think Nitha had a question about the custody as well.
Oh, okay, go ahead.
I
no, I
would
was
just say, I think
Yes,
the custody
go ahead.
does end when he turns 18. I think you do have to go file for guardianship. Courtney, you can tell me if you disagree, but.
No, the guardianship was filed and I was just wondering, but we pretty much follow what's written into the pages and pages of custody agreement. We follow it with because we both thought that we had to, and I'd like to kind of keep that in play. So I was just wondering if I can have the guardianship paper updated to state that whatever was in the custody agreement remains in force.
So my experience with the Northern Virginia judges is if you've got an agreement on that and you want to put that into the guardianship order, they'll do that. But
Okay, thank you.
yeah.
Thank you.
Is that
Thank
your
you.
experience, Kate, in the other jurisdictions that you work in?
Yeah, I would agree with that. If you've got a consent order and it's nothing in there is super wacky and the judge thinks it's in the
Or illegal?
child's best interest, then they'll do it. You know, another order they can sign and get off their desk.
Yeah, I just have to somehow get my ex to agree to get it updated. That's all. Okay, thank you. Thank you.
Tia, you're on mute.
Thank you. Thank you. Is there any advantage to filing or seeking counsel in Maryland or DC versus Virginia, or are you only allowed to file where you have resided for X amount of years?
I would
So
say
you have
that,
to go ahead, Kate.
I was just gonna say, I think
No, go ahead.
divorce is different than guardianship. You know, a divorce case, they have residency requirements. Usually it's 6 months, where the party has to have, one party at least has to have lived in the jurisdiction for at least 6 months. For guardianship, typically the jurisdiction is going to be based on where the adult resides. So it's a little different
What adult?
with the person alleged to need guardianship.
Thank you.
Same in Virginia.
Okay. Okay, person with disability, sorry. Next question. Oh, I can't remember, Florence. I think you're Virginia, and you said here. I have a 23-year-old son with serious mental illness. I live in Virginia. I gave up my career 25 years ago to be the primary caregiver. I have been married 27 years. My husband committed adultery, then deserted his family. I have a lawyer in Arlington. I am fighting for financial survival for both myself and my son. I'm 60. I do not feel my lawyer is truly advocating for me based on the circumstances and our earnings. I have limited funds because I am a caregiver. I cannot afford a court hearing, ?
So there's Legal Services of Northern Virginia. Depending upon the economic circumstances of the potential client, you may be eligible for them. I know Fairfax County Bar Association has a program, and I can't think of the name of it right now, but if you look at Fairfax County Bar Association, where they have lawyers who will agree, they screen them for their finances and will do a sliding scale. The Women's Center in Vienna, I think they still do that. They used to have something similar set up where they had a list of attorneys who are willing to take on cases based on sliding scales as well. So those are 3 resources that I would recommend looking into if you feel that the attorney you have is advocating for you and the concern is that your finances are limited to afford an attorney. And if nothing else, I mean, you can at least you can do a consultation with another attorney who may be able to evaluate or give you just an overview of whether or not things that are happening seem to be typical or not, given the circumstances. I will give that a caveat, though. It's kind of hard sometimes. I've done that before, where clients have come in and they've given me, you know, their viewpoint of what's happening, but there has been critical information that was missing that they didn't know was important enough to tell me, and I didn't know that it existed. So, you know, whatever consultation I do and advice is always going to be based on the information that I'm being provided. So it would be important to provide as much information as possible if you're going to seek a second opinion.
Thank you. Okay. Almost done with typing that. Next. Want a single mom without residence and work on her own, never married. Now the father wants to take away the children. Both have special needs. I don't know if he wants $300. He's married and has a good job. And the mom, I guess, is afraid that they're going to take away the kids. So I would say, again, does legal services require any type of identifying information? Kate or Courtney, do you know?
I don't know.
Well, they're gonna require your name and everybody, you know, the name of the children and the name of the spouse, because they have to do a conflict check. and
Right,
make
but I mean,
sure
do you have to be a legal resident to, or whatever we call this now, to use the
no,
services?
I don't believe you do.
Yeah.
But you'll have to provide your financial circumstances as well.
And then if they're multicultural services, and then if Spanish speaking, Ayuda is also, they have attorneys. Ayuda has attorneys available. Okay. Yeah, so I would recommend seeking legal services through one of the free options, which would be, as was mentioned earlier, legal services, multicultural services. I don't know if they have attorneys, but they have people that can speak a variety of languages and speak to a variety of topics. And then if you are Spanish speaking, or the person we're talking about is Spanish speaking, Ayuda. Does child support extend? Go ahead.
Can I just say, I would say in general that I'm sure Courtney has this too, where you have clients who say that a spouse has threatened to take the children away.
Yeah.
And in general, the court is looking at the best interest of the children and is going to, in general, weigh in favor of both parents having access with the children, because parents have constitutional rights to have access with their children, except in, circumstances where the child is in risk of harm. So I think that if someone's spouse is making threats about taking the children away, the court it is unlikely that will happen as a whole. The court is going to look at the best interest of the children, and in general, the court is going to give both parents access for the children. What type of access and under what conditions, I can't say, but it's unlikely the court is going to enter an order saying that one parent has no access for the child.
Thank you. Okay, I added that to the answer. Does child support extend to people on the autism spectrum, college-age children? So those are high functioning. So high functioning autism, a person with high functioning autism who's going to college, would child support extend to them as well?
So in Virginia, the definition, there is no bright line rule as to what diagnosis and whether or not that diagnosis fits under the definition of disabled for purposes of extending child support. As the slide said, you have to meet the criteria of permanent disability, unable to live on your own, and living in the home of the parent who is seeking support. That's an interesting question that's come up before about, well, are they actually living at the parent's home if they're out in college? And it just would be a fact by fact determination by a court, because I can see a judge saying, well, if they're capable of going off to college and staying at college, then why couldn't they live on their own? And maybe they might need extra supports in place to help them, but why couldn't they? If they're still living at home and they're going to college, well, that's a different scenario, because a judge might be less likely to say, oh, well, they can live independently just because they're going to college. So it really is, that is a very fact-specific situation as to what the court would do on that.
I think that's true in Maryland as well.
Thank you. For support, does the child need to apply for SSI first and then the court determines the other income from child support?
I don't think it matters if they, let me think about this. If they, well, I guess it depends on whether they're actually receiving, if they're over the age of 18 and there's actual support being paid, then they need to get that support irrevocably assigned to the special needs trust, or else that amount's going to be counted against them for their eligibility for SSI. If there's not actually child support being paid at the time, then it would be fine for the child to apply for the SSI. And if later you're going to seek that child support be paid, you just need to make sure again that it's paid irrevocably into the first party special needs trust.
I think a parent
So-
could, let's say you're the parent who is, someone is claiming that you should pay child support. I think that parent could say, well, this child, the amount of support I should pay should be less because this child could get SSI and just hasn't applied for it yet. I think that person, you leave yourself open to that argument if you haven't done that yet. But I think you need to make sure you have your ducks in a row in terms of assignment, like Courtney said too.
So,
Well, and that can cut both ways, because you could have the child doesn't have the SSI and you're going for support, and the parent who's going to be paying support says, well, they don't have it, and the judges said, well, they don't have it, I'm doing it based on what's now. They'll set it, and then down the road you get the SSI, and then that parent can come back and say there's been a modification. Now there's financial resources. Again, that goes back to what I said way earlier in the presentation. My experience has been that judges typically don't, especially SSI, don't factor that in unless they think it's a hardship for the parent who's paying to pay the full amount that they were to pay.
now what you said on your slide referred actually to SSDI and not SSI.
So SSDI, there is if a child is receiving in Virginia, if a child is receiving SSDI, and that SSDI is a derivative of a parent's work history, then when they do the guidelines, the amount that the child receives in SSDI gets included in the guideline amount. It's actually added to the parent's monthly income. And then when the bottom line comes up and says, okay, parent, you owe X amount of dollars, then it's deducted from that X amount of dollars, dollar for dollar, what was received. So if the parent has $1,000 income and the child's receiving 500 in SSDI, then when they do the calculations, that parent's amount is 1,500. And then at the end, when they say, okay, you owe $600 in support, minus the $500 that they're receiving. That's how they do that. But that's only SSDI derivative from the parents. I had one 2 years ago, and the child was receiving SSDI for themselves, that they had worked enough quarters. Despite their disabilities, they had worked enough quarters and had gotten it off their own record. And the court did not put that in.
Okay, so I think that it's important to step back from all of the. I don't think that how frequently has precedent been set that SSI has been taken into consideration whenever somebody is asking for child support. I think I only saw it once maybe in Virginia, but I haven't looked in the last couple of years. So
Yeah.
a supplemental security income is not guaranteed. That's a means tested benefit that may be available to the person with disabilities. The recommendation that the ARC usually gives is apply for adult disability at 18 years and 1 month. Do it as soon as you possibly can, basically, because you just get it set up, get the system going, there's no real work history for that individual, and it's in place. And later on, if the person doesn't need it, great. If they do, they continue to get it. And then I would always push, wouldn't even bring it up personally, unless the other spouse knows about it and knows that maybe their attorney would want to factor it into that level of child support, but it's not guaranteed income. It's very different from Social Security disability when it is a derivative of the parents. And that would be something that probably popped up later down the road. So my advice is always to apply for the adult disability as soon as you possibly can, get it on record that the person is receiving it, And then, child support, as both attorneys have said, is not just room and board. It's also clothing, it's tuition, it's medical care. I mean, there are many, many other things that child support is meant to cover. So it is 12 o'clock. We would normally end by now. We still have 25 more questions. I know we're not going to get to all of those. How much more time, Kate and Courtney? Do you have another 15 minutes, or do you need to sign off now and move on?
I have 15.
I do too.
Okay. So next question. My child has autism level 2, moderate. So moderate autism, ADHD, a specific learning disability, and severe food allergies. So it's unknown whether he will be considered disabled at 18 or 19 or not. Whereas I would say, yeah, for sure. But we have an ARC of Northern Virginia Special Needs Trust for him for Medicaid allowable college savings, just in case. So it actually extends way beyond just, never mind, we won't get into what the trust can cover many things. I'm the mom and the spouse paying alimony child support. What would you recommend we include or not include in the property settlement agreement regarding post-childhood support going to an irrevocable trust given uncertainty of a child's future disability status? Either of you?
I'm not exactly sure how to answer that. I mean, when there's so many unknowns, it's hard to plan for the future. Depending upon the resources of the family and a little more circumstances, that it's too hard to meet out in this forum. Sometimes I recommend that my clients consult with a financial advisor. Maybe we're looking, because there's going to be a combination of things. There's going to be life insurance, because you want to make sure there's money there down the road if you're not there to do it. It also sometimes depends on how cooperative the parents are with one another. If they both have the same viewpoint as to the importance of, first of all, the level of disability for the child, and also the importance of providing for them. There are some times where it is more of it's a trust issue. Really, I trust, even though we're divorcing, I trust that my spouse believes and agrees with me on the level of disability my child has and will support them. Sometimes there's a combination of that. That's not always the most comforting advice to give clients when and it's certainly not comforting if you've got a situation where there are spouses that don't see eye to eye on things, or there's concern that one's not. But like I said, life insurance is certainly an issue. Maybe if you're looking at a third-party special needs trust, putting some money into that. It's hard when you don't know whether there's going to be the disability down the road. Certainly the estate planning, I've had provisions in settlement agreements where the parties agree that they're going to provide for their children in their estate plan. I've had them be as vague as that. I've had them be a little more detailed to say, that we agree we're going to fund, a special needs trust, a third party special needs trust for this child in the minimum amount of X. Or I've had them say, percentages, I'm going to make sure that 50% of my estate goes to them, and maybe not even say it has to go into special needs trust or not, because the situation is fluid and you don't know down the road if a special needs trust is going to be necessary, or if they've got some sort of disability now that they could improve to the point where they don't need the protection of a special needs trust.
I would say you could also perhaps put in the agreement, it's not going to be a slam dunk enforceable thing, but you could say, we recognize that our child presently has these conditions. We recognize that he or she may need support past the age of 18. We agree to, if we're not able to agree at that point, we agree to attend mediation with whomever and to discuss these issues. And we agree to take, perhaps someone's recommendations into consideration. And if you make statements about like, the child's condition now that you can agree on, you could then use that as if you had to go to court later to say, well, if the other spouse later down the road tries to dispute the condition, you could say, well, here, you signed this agreement where you recognize that this child had this agreement, and we agreed that we would consider these things further down the road, and this might be a possibility. And that's not going to win the day for you, but a court might consider that as persuasive if you have to fight about it later on.
And we have our next First Fridays on April, I don't know what, I'm going to say the 4th, but I could be wrong. I don't have a calendar in front of me, is financial planning and finding that sweet spot when planning your retirement for 3 or something along those lines. So where I thought the same thing what Courtney said in the beginning with finding, it sounds like you need a financial planner who understands special needs, not just somebody who's selling insurance, but somebody who's actually certified to talk about assets and resources and whatnot. And I too have seen through estate planning attorneys what they both attorneys referred to, in that there's language in the estate documents. One of the attorneys I work with says, I always throw in a third-party special needs trust just in case they need it. And then there's wording in the documents that allow for, if the person indeed is receiving government benefits or needs to be receiving government benefits, that trust has already been drafted. Okay, so here's another one. Spousal support. Thank you. April 2nd, First Friday, is finding that sweet spot when planning for retirement for 3. Good. Husband and I have been separated since June of 2019, attempted to negotiate a settlement for a year. Filed for divorce November 2020 in the Virginia Beach area. Husband is retired military officer, gets retirement, additional retirement for disability occurred due to service. Combined, we make over maybe 100,000 and not 10,000. Husband filed for a pendente light hearing for both spousal and child support. He makes twice as much as I do between retirement and salary. Question: would the judge be able to award reimbursement of my legal fees due to this unnecessary hearing?
The short answer is yes, the judge could do it. The long answer, and I will say the caveat, I don't practice down in Virginia Beach, so I don't know if they have any particular local rules that they follow. My experience is typically I see a lot of judges don't award attorney's fees in the pendente lite, the temporary arena. They tend to pass that down the road to be something considered in the final hearing, unless there is, unless the judge sees that there is a huge discrepancy in income and the party who is seeking the support really needs the money. And there's also the ability for the court to award what's called suit money in the beginning of the case to require one spouse to pay money to the other spouse so that they can maintain the suit. Again, that's something that we don't see very often. The financial circumstances between the parties have to be pretty inequitable, but sometimes even then the judges don't do that. Or the other circumstance, well, I will see them do it in a temporary, is if they do believe that one party is using the litigation abusively to try and force the other person not to be able to proceed. Again, it has to be pretty obviously egregious to a judge, in my experience, before they'll do it on a temporary basis. But again, not always.
So, anonymous, daughter is 17 years old. She spends 2 weeks with mom, 2 weeks with dad. Daughter has a family-funded special needs trust and a self-funded special needs trust from June of 2019. Both special needs trusts are with the ARC. My lawyer received a letter from OPC that daughter's father has retained a lawyer to create an additional special needs trust for child support purposes. Question, is that necessary? Couldn't we just use the special needs trust she already has? No, it's not necessary. Yes, you could use the trust she already has. Is this usual practice during the divorce to obtain an additional special needs trust? That I don't know if that's normal. I mean, what I know is most parents, a lot of parents agree just to use what's in place because it's especially when it's with the ARC/a third party entity that's objective. Go ahead, Courtney.
Typically, the only time I see a party insisting on creating a brand new special needs trust when there's already one that is perfectly acceptable. Typically, I only see that it has to do with who's actually the trustee of the trust and therefore has the ability to control the management of the trust. And I've had that in contentious situations where, each party created their own trust for the benefit of the child because they could not agree on common ground on who would be the trustee. And so I've seen them do that. I think that's.
So what about, so Courtney, looking at it this way,
it's a bad waste of resources, I think. But.
Right, it's a bad waste of resources. And if the daughter's father wants to be the trustee of that first party trust, he continues to maintain control over the funds as well as the other's parent trying to get money out of that trust. That's how I see it. I see it as an aggressive act, personally.
It may be, it may, there are also times where, the attorney is not being provided enough information to understand that in fact this other vehicle exists. So, there are times where it really is just a lack of knowledge that it actually already exists a trust in place that will satisfy the requirements.
I think also it's just because you create a trust, there should be an agreement or a court order saying where the child support has to be paid. And so, dad may be creating a trust, but I would question whether if you can't ultimately reach an agreement, which obviously is the goal, then, perhaps you can rely on the order as to where the support has to be paid.
Yeah. Sorry, typing. The support has to be paid. Let's see. I'm trying to jump to some other people that have asked. A divorce decree, this will be our last question, guys. A divorce decree in 2010 was made with no consideration of my son's disability. He turns 18 in September. Will anything happen to force some kind of action on the decisions that need to be made, especially if there is a conflict among spouses?
So which issue are we talking about? Support? If it's child support, then if he meets the criterion, and this is Virginia, if he meets the criteria for a disabled child, which authorizes the eligibility for continuation of child support, then you can continue through the court to obtain that. If we're talking about custodial issues, I think we've already addressed that in the fact that custody ends when they turn 18. I'm not sure what else.
Yeah, I think, I'm hearing what you're saying too, because you have to file a petition. There's nothing that's going to trigger this reconsideration of disability, correct? In either jurisdiction.
Right.
Well, what I understood, go ahead, Kate.
I was just going to say, I think child support will end and somebody's absolutely got to go to court to make that continue, so long as the order or agreement presently doesn't provide for it to continue. In terms of decision-making, I often have parents come to me and say, the child may be 21 or 22 or even older, and they say, well, his day program or something said I had to get guardianship. And so that's where it's typically for the decision-making piece for guardianship, it typically comes up because somebody realizes that they can no longer look to the parent as the authorized decision maker anymore. And it may be 4 or 5 years past the time when really it should have been done, but that's typically how it comes up. But nobody's going to grant either the support or the decision-making authority without somebody initiating the court process.
Right. So Colleen, someone needs to initiate. Sorry, typo. The process. All right, we'll save the other questions, guys, because there are many, many more, many very good and very valid questions. I want to make sure Evelyn saves all these for us to get to. And like I said, we'll send out a Q&A. Don't expect it this week, I can tell you that. Maybe next Friday, maybe the following week. I'm still behind on other ones. Can you maybe bring up Kate's slide, Evelyn? You've had Courtney's up for a while, unless we don't have Kate's. I don't know. I can't control that. There we go.
Should.
Yeah, there it is. So I want to thank both Kate and Courtney for today and spending a good 2 hours with us talking about these issues. I'm also very excited and ecstatic that so many people actually joined in, because this is something that a lot of people don't know about. And Kate and Courtney are both well versed in family law, the guardianship, of course, as well, but also family law, custody, and children with special needs. And it is, I think, so important to get it right the first time, just for peace of mind and being able to wash your hands of that divorce and walk away and say, we have it all in writing and it's been ordered and I don't have to deal with it anymore. And then also for, it's just a good security overall for everyone and knowing what's in place. And then when laws do change, of course, it's important to go back and review the documents. But I know both Kate and Courtney are able to address these issues, because not all family law attorneys, and I will say this, I'm going to actually be so bold as to say that most family law attorneys don't understand the special needs portion of the situation, and many need to be educated on it. And I know there's efforts to do that, but it's just so important to work with people who know from the get-go what's what, so that you're not paying them to research. Sorry, guys, but the fact of the matter is, if your attorney is not up to date on the facts, then they're either going to, hopefully they'll educate themselves on it and talk to other people, but there's no guarantee that they will. So be sure you're working with people that know what they're doing, like these two women. And Courtney, your office is in Arlington. Kate, you're at Tyson's primarily, but I know that with you serving other.
Yeah, my office is in Bethesda. We have an office in Tyson's, but yeah. And I don't do divorce work and stuff in Northern Virginia. Mainly Maryland for that.
And I'm looking at it and seeing Bethesda. There it is. Okay, good. Thank you both very, very much. Stay healthy. Happy St. Patrick's Day soon.
Thank you. I know, Mcqueen and McCarthy, we're going to be celebrating, right?
Socially distance, of course.
Exactly.
Well, thank you for having me.
Thank you.
Thank you both. And we'll send out everything to everybody. And this afternoon, you'll get the slides in the webinar. But like I said, 1 or 2 weeks before you'll get an FAQ. All right. Stay well.
Thank you.
Thank you.
Bye.
Thanks, everyone.
Thank you.
Thank you.
Karen, do you need,
Yes.
you're still recording, right?
Yep, let me stop.
So I'm gonna save the FAQs and send that over to you.